Maritime liens and ranking of priorities according to the Cypriot law. Cyprus has the fifth largest fleet in the world with a total of 2,800 vessels of approximately 29 million tons. Cypriot vessels are frequently involved in lengthy court proceedings throughout the world, and it is often the case, especially in civil law jurisdiction, that reference is made to the applicable laws of the country of the flag of the vessel. This article purports to address the issue of the priority of maritime claim under Cyprus law. It should be noted from the outset that a considerable number of the cases has been decided by Cypriot court on this legal issue, providing for some clear and detailed rules. However, it remains always at the discretion of the court to vary and/or reverse to other of priorities depending on the special circumstance of each particular case as well as on consideration of equity and natural justice. Maritime lien. In Kemal Hazanin versus Hellenic Island and/or Island and Others 1994, it was held by the Supreme Court of Cyprus that, by virtue of Section 29 of the Court of Justice Act of 1960, the source of Cyprus admiralty laws spring from the English admiralty laws as those were applied in England prior to Cyprus becoming an independent country 1 October 1960. Therefore, it should be clarified from the outset that there exists many similarities between English and Cyprus laws on the issue of maritime lien. The concept of maritime lien arises under Cyprus law by virtue of Section 3 of the English Administration of Justice Act 1956. Although the 1956 Act doesn't clearly define what is a maritime lien, it has been widely defined as a privileged claim over a vessel or other maritime property in respect of services rendered to or injury caused by that vessel or maritime property. Where there is a maritime claim on any vessel or other maritime property, the admiralty jurisdiction on the Cypriot court may be invoked by an action in rem against the vessel or maritime property. A maritime lien may be so invoked against the vessel or other maritime property even in the hand of a bona fide purchaser who knew nothing of the claim. The main categories of claim in respect of which Cyprus law recognizes and upholds maritime lien are as follows: bottomry, salvage, wakes, master's wake, disbursement and liabilities, and damage done by a ship. It should be noted that under Cyprus law, maritime liens enjoy certain advantages over all other permitted action. In rem statutory lien, under Cyprus law, a mortgage is a special type of statutory lien. As to the time of creation of the lien, in priority and enforceability of security. Under Cyprus law, a maritime lien has a procedural nature and depends on the remedies available in the country where relief is sought lex fori. Kemal Hazain versus Hellenic Island or Island and Others 1994, Cypriot court in determining the existence of a maritime lien will apply Cyprus law. Even in cases where under a different law, a maritime lien does exist whereas none exists under the lex fori, Cyprus law. It is worth noting that in obiter dictum in the Kemal Hazanin case, Judge Artemis held that it would be more equitable and reasonable to accept the approach of the Lonin Dascalis. Therefore, in my opinion, the existence of a maritime lien should be considered as having a substantive nature and be decided according to the lex loci contractus. If according to the lex loci contractus a maritime lien arises, such a maritime lien should be recognized by Cyprus law. However, the rank of priorities of this maritime lien should be decided according to the lex fori. However, Judge Artemis went on to concur with the majority judgment of the Supreme Court of Cyprus, and no further emphasis was given on this point. According to the ABC Shipbrokers Ltd versus Prescott Shipping Co. Ltd., a person who has paid off the privilege claimant, a ship manager paying crew and master wages, doesn't stand in the shoes of the privilege claimant in respect of his maritime lien. This person can be considered only as a volunteer who has decided to pay off a debt which constitutes a maritime lien on the vessel. However, by his action, he didn't acquire any maritime lien and therefore had no right in a rem based upon a maritime lien. In the above case, Judge Piotis further held that a person who, at the request of the owner of a vessel, pays off the crew will stand as a necessariesman and thereby possess a statutory right of action in rem against the ship in respect of his advance. But necessariesmen have no prior equity because a lien for necessaries is a statutory lien and it is not attached until the institution of an action in rem. Thus, in principle, a statutory lien doesn't crystallize into a maritime lien prior to an action in rem being filed with the Cypriot court. In Commercial Bank of the Near East Ltd versus the ship Pegasus 3, the Supreme Court of Cyprus upheld the general principle of English law by deciding that although master disbursement give rise to a maritime lien, necessaries only create a statutory lien which is enforceable against the vessel only after the institution of an action in rem. It should be noted that although Section 3 of the Administration of Justice Act 1956 enables a claimant to arrest a vessel to which a maritime lien attached, no provisions are contained therein in respect of the arrest of a sister vessel. However, this situation is compensated by Section 3 of the 1956 Act, which provides that the admiralty jurisdiction of the High Court may be invoked whether the claim gives rise to a maritime lien over the vessel or not by an action in rem against any other ship which, at the time when the action is brought, is beneficially owned as aforesaid. However, it should be distinguished that in such cases, a person who possesses a maritime lien in respect of that other ship has no higher right or priority than that enjoyed under the circumstance by a statutory lienee. Cyprus Admiralty Court are vested with jurisdiction under Section 19 of the Court of Justice Law 1960, Law Number 14, to determine question of priorities, as the Administration of Justice Act of 1965 Section 3 and 7 gave the High Court in England sitting in Admiralty jurisdiction to determine a question of title to the proceeds of sale of a vessel by an order of the court. This jurisdiction is vested in the court and may be exercised in the first instance by any judge or judges. Thank you.